Hi, Amy Pittman with Pittman Law Office, and today's video is what is the number one mistake that families make when planning for elder care? Well, I would say the number one mistake is not planning. So the planning must be done by the client, the patient, the individual who is needing care later in life. So by pre-planning, by making sure that you have a proper estate plan, that's going to make that part of your life, if you become incapacitated, a little easier for your family or loved ones. So we want to make sure that you have a durable power of attorney. And that is a financial document that is allowing you to name someone to make financial decisions for you when you're unable. But the benefit of having that durable power of attorney is the agent that you name, that's the person who's going to be in charge if you're alive but unable to act, can actually have access to all of your finances. If you're running out of funds and they feel like you need to go into a nursing home, they can work with a Medicaid planning attorney, which we don't do, but we do refer you to a Medicaid planning attorney, and they can get you qualified for Medicaid. So again, we want to make sure that durable power of attorney is in place, because you can't sign one once you're incapacitated. And when you have that ahead of time, it's going to allow that easy transition for someone to step in and make financial decisions, to maintain your assets, make sure your bills are being paid. The other part of that is your healthcare. Who's going to make the medical decisions on placement? Are we going to have home health? Or are we going to go to the assisted living? So obviously, if you're confident, you can make all those decisions for yourself. But what happens if you're not? And a lot of times we don't know when that's going to happen. So we want to make sure that you're naming someone as your healthcare surrogate who can make medical decisions, who can deal with your providers, who can make tough end-of-life decisions. And this person can be anybody, as long as it's someone that you trust to be that advocate for you. But again, that healthcare surrogate is making all medical decisions. And of course, they're going to have to work with the person you name as power of attorney agent to determine, what you can afford as far as placement. And that healthcare surrogate is also the one that will enforce your living will. And the living will is going to say if you don't want to be artificially prolonged in certain conditions. So we definitely need a plan. Obviously, if you're local to a Pittman Law Office, feel free to call and schedule a consultation for your estate plan so that you have it ahead of time. If you don't have it, then we would have to refer you to an attorney that does guardianship, which is expensive and time-consuming. And I also note that we do not do Medicaid planning here at Pittman Law Office, but we do have several referral sources that we send our clients to if they are in need of nursing home Medicaid. So don't fall in that mistake of not planning. Please plan for that potential incapacity to make it easier for your loved ones and your family members or whoever you're going to put in charge, because you don't want the state making that decision for you. All right, hope that helps.